the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three cases. We have Judge Keenan with us remotely. Good morning, Judge Keenan.
Good morning, Judge King, Judge Richardson.
Morning.
And let's see here. The first case we have is U.S. versus Suero. Did I mispronounce that probably? Mr. Bodner.
Good morning, Your Honor.
And you may proceed. You can come forward right here if you will.
May it please the court, I am Mark Bodner representing Mr. Christopher Robert Suero, and frankly, Judge, I'm new to the case, so I don't know how to pronounce his name either. So I hope that's right.
You didn't have the previous appeal?
No, sir.
Okay.
I was appointed following the decision on remand from this court.
Okay.
May
It's
it
good to
please-
have you with us.
Thank you, Judge. It's great to be here. I'd like to start off my argument by addressing what I believe to be the more significant condition of supervised release that Mr. Suero is challenging, and that's the special condition of release number 6, which is the lifetime bar on his being involved in employment or with minors or computers without prior approval of the court. That's the modification. That is, the prior approval of the court is the modification that Judge Alston made to what was the lifetime bar that this court struck on appeal. And I have a number of reasons why I believe that the prior approval of the court does not resolve the difficulty in preventing Mr. Suero's reentry into employment once he finally leaves prison. The court may remember that he received a pretty stiff sentence of 20 years, and I understand his offenses were very serious. But the reasons are as follows. Number one, I believe that requiring prior court approval before he can obtain employment involving minors or computers is a greater restriction than is necessary to achieve the goals of 3553A that are designated to protect the public and provide for deterrence, et cetera. And the reasons, the most salient reason is that there are uncontested conditions of supervised release that seem to provide the protection that don't warrant having to proceed to court and somehow hope to get approval, which may or may not be granted by the court. Those uncontested special conditions are numbers 4, 5, and 11, and I can describe them briefly as follows. Number 4.
So you're challenging four conditions.
I'm challenging number 6, which is the employment bar
Okay,
without
you're tying
prior.
number 4, 5, and 11 into 6.
4, 5, and 11 are uncontested. In other words, Mr. Suero was
Okay.
fine with them and did not challenge them. And number 4 requires him to have mental health and sex offender treatment. Number 5 requires that he submit to polygraph testing, should that be determined necessary by his treatment people or his probation officer. But most significant is condition number 11 requires him to have any computer device monitored by the probation office in accordance with the software that they ordinarily use. So the question is...
Mr. Bodner?
Yes, Your Honor.
Mr. Bodner, I have a question. Is number 11, in your view, then less restrictive than number 6?
That's
and
our...
if so, to what degree? Could you explain your understanding of the differences between 6 and 11?
Yes, Your Honor. Of course, 6 requires prior court approval. And we don't know what conditions Mr. Suero would have to meet to obtain prior court approval. What we do know is until he obtains it, he's barred from employment on the lifetime basis. I understand that the prior court approval is supposed to break through that lifetime bar, but it's unknown what may happen. Number 2, he may or may not have counsel. He may not be capable of sustaining the expense of counsel to approach the court to obtain the approval. I believe that condition 11 is less restrictive because his computer devices are going to be monitored by the probation office, and it provides the protection that you would think the prior court approval is designed to provide to the public. That is, if he has employment involving computers or minors, necessarily there would be monitoring by the probation office and they could see exactly what his use is. It's interesting, the government pointed out in its brief that there is no restriction other than the others that we challenged today, limiting his use of recreational use of computers, but they too would be subject to the monitoring by the probation office. So that's the best answer I can give, Your Honor.
Can you help me understand, with respect to number 11, why number 11 requires a work computer to have monitoring? It seems to me it doesn't require that at all, right? It seems to me the only thing it does is requires that Mr. Suero consent to it. But if I'm Bank of America or I'm Joe's LLC, and I don't want Uncle Sam monitoring my computer systems for whatever reason that might be, legitimate or not, it doesn't require that there actually be equipment put on the computer. If I run a business and I don't want Uncle Sam monitoring everything that I'm doing, which is what the software would effectively do, I could say as a business, no, I'm not consenting. It doesn't require it. So why doesn't it just naturally make sense that both of these fit together? They're not overlapping at all. They require Mr. Suero to consent, but they require the court to provide permission only when the company is willing to install the software. So if the company doesn't install the software, the company is non-cooperative, then that's precisely the scenario which Mr. Suero, who engaged in lots of workplace misconduct to begin with, that's how we got here to start with, would be prohibited from working there. They don't seem to overlap to me. They seem actually to just fit together like two pieces of a puzzle. What am I missing here? What in number 11 requires a business to let Uncle Sam monitor their computer system?
Your Honor's point is very well taken. I think that that's a substantial point. I would simply suggest to the court that being the case, he wouldn't be able to sustain that employment because obviously the employer who has these concerns is going to say, well, we're not going to allow your use of software for this. So it seems to me it would shift the burden to the government to show why he should have this or that employment or not have this or that employment.
No, the point is that, the judgment was made. Judge Alston, who knows a lot more about this case than I ever will, made the judgment that it's too risky to have him using an unmonitored work computer. And so if he can't find a job that allows monitored work computer, he needs to find one that doesn't have computers. The same thing with respect to children, right? If he can't find a job that doesn't require interaction with children, then yes, Judge Alston is making the judgment that that small category of jobs are unavailable to him, right? So too are the small category of jobs. Most businesses, I'm sure, would be perfectly happy to have, child porn monitoring software. Many businesses, I assume, already have it. Right? But if he was wanted to work at one that did not permit monitoring, that's precisely the scenario where we don't want him to have that job.
Well, I don't disagree with what Your Honor has just said. All I would suggest is those would be jobs that he couldn't have because the employer would be unwilling to submit to the condition that the court has imposed.
Do you agree? I mean, you do agree that Judge Alston can say, take the first example I gave, you may not have a job that requires interaction with small children. Is that a permissible supervised release restriction?
I would think that would be permissible, yes.
That's sort of like an obvious example.
Yes, sir.
I think we've suggested in various places, you don't even have to explain that one. That's just like so obvious that it's clear. Well, that tells us that we can have restrictions that limit employment in some way. You can't bar all employment. I get that. Right? But this isn't barring all employment. This is just saying, listen, if we've got an employer who refuses to have the computer monitored for whatever reason, that's not a job he can have in the same way the kindergarten teacher is not a job that he can have.
But as Your Honor also pointed out, there are a whole range of jobs that he could have with the monitoring. And the prior court approval condition seems to preclude that until he comes to the court and says, this is what I have. And
Yeah,
even
I have an employer who will allow my computer to be monitored.
right, but that
And
puts,
if the judge doesn't approve that, if Judge Alston or whoever it will be at that point in time when he gets out of prison and has taken Judge Alston's place, he has an ability to challenge that. If that judge unreasonably withholds that, he can challenge that, right? That's a challenge that's available to him. We certainly are not going to presume that that judge in the future is going to be an unreasonable human being who refuses to allow him to work in any job.
well, two things about that. One, he might encounter a judge who, looking at his record, says, or has in the back of his or her mind, this really is a very unappealing applicant, number one. But I think more to the point, it's a greater restriction than is necessary to put him in that position than to have the monitoring, which is going to show the division between those jobs which he can have and those jobs.
Do you think that Judge Alston could have ordered all employers to accept monitoring?
Oh, no, not
Right?
at all.
So then the monitoring doesn't help, right? Because what it's telling us is that he has to consent to it, but the employer does not.
No, I think it does help. I respectfully disagree with Your Honor to this degree, that the monitoring opens up a range of jobs that he can have, and that is a greater restriction to say, come to court before you can have the job, than to say, these are conditions that adequately protect the public, because there are going to be some employers who will not have him with the condition. And that's where he can't go, but that's not a danger to the public if he doesn't have that job.
So, but just so I understand, if we were to strike out condition number 6, right, so that was no longer a condition?
Yes, sir.
And he went to a company, Joe's LLC, and they employed him, and he told Joe's LLC, I consent to monitoring, and the company says, no, I'm not gonna have any monitoring. If we've eliminated number 6, he can just go to work there, and he can use that computer unmonitored, without any restriction.
That presumes that the probation officer does not know what he's up to. Because
Why would it matter? He's not violating any condition. He can use an unmonitored computer at work because you've told us we gotta get rid of number 6. And number 11 does not require monitoring. It just requires his consent to monitoring.
I agree with that. But I believe it's a standard condition that is not an issue before the court, that he's required to notify his employers of his record.
Right,
So-
but I'm assuming that Joe allows him to work there, and Joe is happy for him to use a computer that is totally unmonitored. And he is absolutely permitted to do that were we to strike number 6.
No, because uncontested condition number 11 requires that he be monitored.
Okay, help me understand, and then I'll stop. I'll let my colleagues go. But why does number 11 require that? Because it doesn't say it. It just says he has to consent to it. But you can't put a monitoring on Joe's LLC, their computer, without their consent. And the judge didn't order every known employer in the future to consent to Uncle Sam monitoring their stuff. I just think you're misreading number 11.
I could be, Your Honor, but the way I perceive it is this, that he's required to notify the employer, number 1, that this is my history. He has a probation officer who's going to want and have to know how he's employed, how he's spending his time. And also, the probation officer is going to want to know that the equipment, the monitoring software is in place if he has access either to the minors, well, that condition's been struck. If there's a computer there, the probation officer is going to know that he has access to a computer and use of the computer, and therefore, by the rule, number 11, which is uncontested, he has to consent to the monitoring. And if he doesn't, I suppose the probation officer can say to him, you can't have that job. And if he insists, I'm going forward, Mr. P.O., then I suppose the probation officer can go to court and say, this is a problem, Your Honor. So I think that there is adequate protection.
It wouldn't violate, you agree that it would not violate condition 11 for him to consent, but for his employer to refuse monitoring. That's not a violation of
No,
condition 11.
no, I agree with Your
And in
Honor.
that world, he shows up to work and he has an unmonitored computer and he can use it. And he has not violated any condition other than number 6.
I think that number 11 is designed to foreclose that possibility.
It may have hoped to foreclose that possibility, but it doesn't by its very terms, right?
I guess in the universe of possibilities, Your Honor, it is possible. It's hard for me to imagine that a probation officer with a fellow who has this history is not going to be watching him closely as to where he is and what he has access to. I don't know, that may not be a satisfactory answer for Your Honor, but that's the best I can come up with given what is available. I do believe that it's less restrictive. Let me move on to my next point unless the court has other.
How old is this fellow?
He is in his 30s, I believe. I don't know exactly, Your Honor. I just looked it up the other day on the BOP website. I think he's 43.
43. And he had a jury trial
Yes,
before Judge Alston,
yes,
and he got 20 years.
yes.
How much has he served?
I looked up his release date, and I believe it's 20. Give me a moment, Your Honor. I thought I wrote it down. It's 2030 something. So he's at least, I believe he's 12 years from his release date now.
None of these things kick in until he released.
Your Honor is correct, yes.
And we review all this for abuse of discretion.
Yes.
Judge Keenan?
No further questions. Thank you.
Thank you very much, sir.
I'm sorry.
You saved some time. You're in the red numbers. You see
Oh,
that?
I apologize. I didn't even realize that.
This your first time arguing down here?
No, sir, but I know the lights, and I wasn't
I'm
looking, so
sorry.
I apologize.
No, don't you apologize. We really appreciate what you're doing, but you got some more time reserved.
Can I raise a main point on rebuttal during my rebuttal
Well,
time?
you go ahead, if you got a main point.
I would take away the rebuttal time now just to make this other
Well,
point.
sure.
I should have done that. I didn't think it would go this quickly, frankly. Next time I'll be more careful in making the adjustment. But I also argue that the Judge Alston, for all of his wisdom, did not address the argument by the government, because they changed their position before they came here, that these other uncontested conditions, 4, 5, and 11, would be sufficient. It was the government's position that there was no need for a lifetime bar
So the government
because you had these
conceded
protections.
your position, you say?
I'm sorry, Your
The
Honor.
government conceded your position?
No, it was their position coming out of the gate.
Their position.
And Mr. Suero's counsel on remand said, we agree with the government.
So that both sides agreed, but Judge Alston didn't agree with you?
Judge Alston did not agree, and when we got to this point, I learned when I received the government's response that they no longer agreed with with their earlier position.
Now they're supporting Judge Alston.
Yes, Your Honor.
And
And I contend
but
that
you're saying that abuse of discretion review is not broad enough to permit Judge Alston to disagree with both sides?
I think my argument is, I'm sure my argument is, that Judge Alston didn't address the argument that I just made before the court, that uncontested special conditions 4, 5, and 11 were satisfying to the government that was sufficient protection, that there didn't need to be a lifetime bar. And
You're not arguing that the district court's discretion in imposing a sentence, whether supervised release condition or otherwise, is limited to like choosing between the government and the defense's
Oh, no.
arguments, right? That it's not like baseball arbitration, right? Where you
Correct.
get two options and you gotta pick which one, right? The sort of point of a district court judge is that he's got pretty broad discretion to fashion the sentence that he thinks is appropriate.
You're absolutely
And
right.
that's true on the number of years, and that's true on the conditions too.
You are absolutely correct, Your Honor. And my position is, yes, Your Honor.
Oh, I'm sorry, I didn't mean to interrupt. I didn't realize you were.
I can wrap it up in.
You go right ahead, Judge Keenan.
Okay, Mike, it seems to me that you're left arguing the position then that the we've never said that, have we? We've said that as a procedural matter, the court has to address the non-frivolous arguments of the defendant regarding supervised release. So aren't you asking us to go a step further and to say the court has to address the non-frivolous arguments
Of the government?
You've never said that in a case in which supervised release was at issue. This court has ruled that the court is required to address non-frivolous arguments, and that it is an abuse of discretion not to address them, and it is reversible. And we cited two cases in my supplemental brief, which the government has probably correctly criticized, not correctly, but justly criticized, that I didn't raise this argument in our opening brief. In fact, I raised the argument in the opening brief. I didn't cite the authority till I got to the supplemental brief. But there are two cases, Perez, Paz, and Patterson, that are in the supplemental brief that both make the point I just advised Your Honor of.
So you're asking us then to make this point with regard to supervised release now?
I'm asking you to make that additional step, yes, Your Honor. Thank you all for your patience at this point.
And you save some time, as I said.
Thank you, Judge.
Yes, Ms. Bashara?
Good morning, and may it please the court. Jacqueline Bashara for the United States. Judge King, I can first address two factual questions that you had for my colleague. The defendant at this time is 44 years old. That's according to his birth date at JA 96. And his release date projected is May 27th of 2037.
2037.
That's right.
Thank you.
I can start by talking about, I guess, the claim of procedural error with respect to the district court's failure to address the government's non-frivolous arguments. As Judge Keenan correctly recognized, this court has never held that to be required on a defendant's appeal, challenging failure to address the government's arguments. As I said in our supplemental response brief, the defendant waived this argument by failing to assert it either in his opening brief or in his reply brief. Further, both of the cases that he cited in his supplemental opening brief do not stand for this proposition. They both involve situations where the defendant claimed that the district court failed to address the defendant's non-frivolous arguments in mitigation at sentencing, not that this court held that the district court erred by failing to address the government's arguments on the defendant's appeal.
Can I ask the premise question? Do you take the government's argument or the government's statements below about 4, 5, and 11 to be like an argument that imposing condition 6 would be improper? I mean, I mean, maybe you could consider them that way, but they don't read that way. They don't read to me like an argument that imposing condition 6 would be improper. Instead, it seems to be like an explanation of the government's decision to not seek condition 6, for example. But it seems a little odd, even if we were to extend it to the government's arguments, to take this and suggest that this was an argument of what the court was required to do.
Yes, this is an important clarification point, Judge Richardson. This is not an instance where we affirmatively represented to the district court that it would be an abuse of the court's discretion to impose these conditions or that there was no record support for these conditions. What we said, the language we used, was that the district court should clarify that the unchallenged conditions, 4, 5, and 11, could be interpreted to expand to cover the challenged conditions. That was simply one possible solution to this problem. But as you also recognized during my friend's opening argument, Judge Richardson, when it comes to reviewing sentences, there is a range of possible sentencing outcomes. It's not a binary selection. And simply because the district court rejected the government's recommendation, that does not mean that the district court abused its broad discretion in crafting conditions of supervised release.
Do you think that 6 is covered by 4, 5, and 11? Just, I understand that's the procedural point, but just as a substantive matter, do you think that they do? And if not, why?
No, they are not coterminous because, as you correctly recognized, it only applies to the defendant. It requires the defendant to consent to monitoring. But as you observed, there is no restriction imposed on a potential future employer or future volunteer opportunity. And that is a significant area of risk. And I would just point the court to the court's recent decision in Ellis 2. There were actually similar parallel conditions to what we have here, right? There was both the prior approval requirement for internet-capable devices outside of employment context, and there was also a monitoring requirement. And the court still upheld the prior approval requirement and said that it was not more restrictive than necessary under 3583D2, notwithstanding the existent monitoring requirement. Instead, as Your Honor suggested, they're sort of working in tandem to ensure that any computer that he is going to have access to is properly monitored to avoid, recidivism, essentially. I would also just reiterate, my friend characterized this as a total ban. It's not. We know that from this court's decisions in Ellis 2 and Comer and Hamilton, interpreting similar restrictions with prior approval requirements. I can also just briefly address that there is a suggestion that perhaps Judge Alston or whoever might be presiding in 2037 would not properly apply or give approval to Suero. And I just want to push back on that. The suggestion that the district court might act in bad faith or sort of arbitrarily, there's just no support for that in the record. Instead, we know that the district court gave Suero the benefit of the doubt at every turn, especially at sentencing, notwithstanding that the district court observed some pretty unruly and disruptive conduct throughout these proceedings. It declined to apply the obstruction enhancement, and it also sentenced the defendant below the guidelines range. And we know that the district court was particularly attuned to this court's specific concerns in the prior case, Suero 2, because at JA 78, the district court quoted directly from this court's opinion, noting the overriding concern about rendering Mr. Suero essentially unemployable in our modern world. That was the language from this court's opinion.
If we're going to presume anything about what's going to happen in 2037, it would be that the court would act properly.
Exactly, and this court would be required to follow the district court would be required to follow this court's precedents, which have made clear the importance of a defendant's ability to engage in employment and volunteer services so that he can be properly rehabilitated once released to supervision. In fact, I mean, that is in everyone's interest, including in the district court's interest, to make sure that the defendant can successfully reintegrate into society.
Did you try the case?
I did not, Your Honor. And I would just note that's sort of an additional atmosphere
Did you argue the
here.
first appeal?
I did not argue the first
So we
appeal or the second appeal. And I would just note for you, there's been sort of a rotating cast of characters, both on the government and on the defense side. The only constant in this case has been Judge Alston, who has presided from the pretrial proceedings, at trial, and at sentencing. He knows this case better than all of us in this room, and so well, maybe not better than you, Judge Richardson.
There's no doubt about that.
Okay.
Let's be very clear. I said that in the opening. He certainly will know more about this than we ever will.
Right. So on this record, there's simply no basis to conclude that he abused his discretion.
And everything is governed by that abuse of discretion
Yes, Your Honor.
review principle. You all agree with that? On that, that's something you got the lawyers to agree on.
Yes.
That's good. Judge Keenan?
No questions, thank you.
Thank you. We ask that you affirm.
We appreciate very much your work as well. Yes, Mr. Bodner?
Thank you, Your Honor. I agree with counsel that we don't know, and we shouldn't presume, and I don't presume that there would be a negative view towards my client's approach to the court to request the relief that we're asking here today, really. It just puts the burden on him, and my whole argument, if I wasn't clear to start with, is that there are less restrictive alternatives than putting him in that position. Let me note to the court that the record in this case, Judge Alston candidly, in his memorandum of opinion and order, noted that there was nothing in the case, in the record, that showed that he had any contact with minors. That's at Joint Appendix 84. There was no evidence in the record that he was addicted to pornography. That's Joint Appendix 79. And Judge Alston did say that it appeared that he was progressing to distribution of pornography, but there was nothing in the record, and counsel for the government certainly did not point out anything in the record that would show that he was in distributing any of these things. That's Joint Appendix 84. Relative to the government's argument that my client waived his his argument as to the fact that Judge Alston did not consider the alternatives of uncontested special conditions of supervised release 4, 5, and 11. I don't agree that we waived that. At several points in my opening brief, we made the argument, and that's at pages 63 and 64, where we agreed with the government's position in presenting this, saying we don't see a need for this lifetime bar, and their argument was made at pages 59 and 60 of the Joint Appendix. So in any event, I made this argument in several spots in the opening brief. I thought I had the page numbers, and I apologize for that. In the legal argument was set forth, that is the legal authority, Judge Keenan points out, I'm asking the additional step to be made, that is that it's an abuse of discretion not to address non-frivolous arguments. That appears in our supplemental brief. So the government has had a full opportunity to address this, argue, say why they believe that it's a waiver. I just don't want this court to conclude that it is a waiver, because it was advanced out front where everybody could see it and address it, and this court can certainly rule on it. Your Honors, I thank you for your consideration. Unless you have any other questions, we respectfully ask you to reverse the judgment. Let me say this one other thing. I'm
Go
sorry.
ahead.
I just wanted to say that all the arguments I just advanced apply equally to the other special conditions of release that we challenged in the briefs, and those were the ones relating to Mr. Suero's access to adult pornography protected by the Fourth Amendment. We believe the same considerations I argued to you here show why that is also an overbroad restriction, and relative to his use of computer games that would be connected to the internet. But having said all that, thank you for your patience. You've been very considerate, and your questions were quite challenging. I ask that you reverse respectfully. Thank you.
Thank you, Mr. Bodner, and we really say that sincerely. We couldn't do our job without lawyers like you that take these things on a court-appointed basis. So we appreciate you. And Judge Richardson will now come down and greet counsel, and then we'll go to the next case. You may be seated. We'll wait for counsel to get situated. Our next case, Alfaro versus McHenry. Mr. Osorio,
Good morning, Your Honor.
not butcher your name?
No, that's perfect, Your Honor.
All right. Good to have you with us.
Good to see you, Your Honor. Thank you. May it please the court. So let's start with the point of agreement here. The parties agree that when an IJ makes findings of facts, the BIA must defer to them unless they're clearly erroneous. Where we start to have some disagreement here is it's our belief that in this case, that rather than defer to the IJ's factual findings on the likelihood of torture, the BIA inserted itself into the role of de novo fact finder and disagreed with the IJ's weighing of the evidence. Additionally, even if the IJ committed clear error, it's not proper for the BIA to use this as cover to make its own factual findings. Instead of redlining the IJ's decision and filling in the blanks itself, it should have remanded to the IJ to point out that what it believed the errors to be. For example, if we had the opposite case where the IJ had not found that it was more likely than not that the individual would be tortured, the BIA should then remand, pointing out where there was probable evidence or evidence that the IJ failed to take into consideration. The BIA wouldn't, in its own instance, make a new predictive on the finding of the likelihood of torture. And then third, we still continue to disagree, and I know, obviously, Lopez-Sorto came out in the middle of the litigation of this case. I still think there's some unanswered questions after Lopez-Sorto, and I would point the court to, I believe it's it's JA page 5, the BIA's footnote 5, and in there, they specifically say that an applicant for protection under CAT may propose multiple different chains of events that could lead to the likelihood of torture, but they must establish at least one where each step of the hypothetical chain of events is more likely than not to occur. And I believe that's just bad math because, for example, if you had one entity, let's say the Salvadoran police in this case, that there was a 45% likelihood of chance of torture, you could establish a chain of events that each step in the chain could not have a more than 50% chance, but still statistically you could arrive at 45%. Let's say there were 5 steps in the chain, 4 steps could be at 100%, and the last step, or I'm sorry, you could have different versions that were very close statistically where you wouldn't have to have each chain have more than 50%. I'm not sure if I'm explaining that correctly because I get myself lost sometimes too. But then let's say you could also have here the vigilante squads that had a 10% chance. So in the aggregate, we would be at 55%, but each step in each of those chains would not be more likely than not. So I still think it's incorrect math to continue to hold an applicant to that standard. So going back to our first argument about the clear error, this judge issued a 13-page, single-space, well-reasoned decision. Now,
This judge, you mean the IJ?
yes, Your Honor, Judge Denozo Stevens. And not only did she issue that final decision that was 13 pages in single space and cite it to the record more than 50 times, her review, I would argue that her first decision should have been upheld. Obviously, the BIA had a single member in both cases that dissented, agreeing that they would have dismissed the DHS's appeal. When we consider the Supreme Court standard here of implausible and illogical based off of the record before it, I just don't think that the BIA has satisfied that standard to overturn. And it's critical here when we're considering.
How do you think that we should think about that? I mean, the BIA here is pretty clear that it found there to be a clearly erroneous understanding of the facts. It says it in like umpteen times throughout. It doesn't seem to be confused about what it's doing. And, it's an agency, and so the agency gets some deference in here, right? If they tell us we find this to be clearly erroneous, and as it turns out, like the argument that the BI made, at least hypothetically, for why it's clearly erroneous is at least plausible or more than plausible, why are we, questioning that that's what they're doing? I understand you have other arguments, but you seem to premise much of your arguments on this idea that we should not believe the BIA when it says we find this to be clearly erroneous and gives rational, I know you don't agree with them, but rational reasons for why it believed it to be clearly erroneous. That seems like a hard line for us to police, where we would say, well, certainly seems wrong, but maybe it wasn't clearly wrong. The agency gets deference on that, no?
I would disagree with that because the only permitted fact finder by the regulations is the IJ, and we only give.
No, but that's a different argument, right? You understand that these are sequential arguments that you've made, right? The first argument you've made is that the BIA failed to comply with the clearly erroneous standard of review, right? So when it found the IJ got all this wrong, it says we are doing that by virtue of the clearly erroneous standard. And it says clearly erroneous a dozen times. right, in various contexts and in various ways, right? And so in doing that, right, you've said we should ignore the BIA's words and find that the BIA failed to apply the clearly erroneous standard. And I'm just, on that point, I understand you have other arguments. I have a hard time understanding how we are to do that.
So I guess I would say a number of different things. I know that Your Honor just pointed out a number of different places where they cite clearly erroneous. I would point the court to JA4, where the board specifically states, upon de novo review, we conclude that the respondent did not meet his burden of proof to establish the requisite likelihood of torture upon de novo review.
But
And that is a finding
that
of,
only comes after it says, we found these facts to be clearly erroneous, right? And once those clearly erroneous facts are removed, then I think it's exactly what it's supposed to do, is to then do a review of whether the legal standard is met with the facts that were not found to be clearly erroneous, right? So that strikes me as exactly what courts do all the time. And that's the second order question, but that's only after it determines what is clearly erroneous. And it says, like, unbelievably clearly, right, we conclude the immigration judge's findings of fact are clearly erroneous.
yes, Your Honor. So let's start with where the BIA redline things and then start to insert its own things that then potentially this court might try to defer to. One, they point to the fact that
But before you do that, so you're moving to the second argument, which is totally fine, right? That yes, the BIA found this to be clearly erroneous, but you think it then engaged new fact finding. That's a second argument. I understand that argument, but that's sort of conceding that the clearly erroneous standard was what the BIA applied, right?
Oh, I totally disagree that the clearly erroneous standard was applied. I thought we were bracketing that for the sake
Okay.
of discussing the second argument.
All right, you can go to the second argument if that's where you want to go. That's
Well,
please.
I just think here, so let's look at the evidence that the board relied on. They said that DHS submitted evidence that there is sort of a non-gang tattoo culture. But what does that show us? Does that show us anything with regards to how those individuals are then later treated? And that evidence all predates the state of exception that is currently taking place. And the IJ was very specific in her second decision to point that out, that the conditions have worsened because of the state of exception. All of that evidence predated when the state of exception in El Salvador started. And additionally, the board relied on an outdated State Department report to try to rebut the later country conditions evidence that the IJ relied on. So it seems weird to say, like, well, look, the board can slash out the IJ's, current fact finding, and we're going to go back and we're going to rely on stale evidence to try to rebut that without taking into consideration. It's almost, it's almost a little comical to me that the BIA doesn't reference any of the state of exception evidence when overturning it, when clearly that would be a massive change in country conditions based off of the profile of an individual fitting the petitioner here. So,
Mr. Osorio?
yes, Your Honor.
Excuse me, sir. The BIA seems to be or appears to place great emphasis on a distinction of the record evidence of likelihood of being tortured versus likelihood of being mistreated. So could you go over for us the evidence in the record that you say that they ignored regarding the likelihood that Mr. Paredes would be tortured as opposed to mistreated should he be returned?
Yes, Your Honor. So I would point the court to JA 103 of the IJ's decision, where she specifically discussed it, how there is arbitrary detention of many individuals without gang ties, and goes and gives a number of different sites to the record there. Also, that police and other security forces have been...
To tie that back, is your argument that arbitrary detention, like by itself, is torture?
Not by itself, but I was going to
I just
sort
want
of
to tie
aggregate
back to Judge Keenan's question, which I was interested in, is that because she's trying to distinguish between torture, or she's trying to get you to distinguish between torture and mistreatment. And your first example to that is that there's some arbitrary detention that's taking place, which seems to be on the wrong side of the line that you're arguing, right? If that's the best evidence that you've got, is that there's some arbitrary detention, that doesn't seem to suggest that the finding that it's only mistreatment lacks substantial evidence.
Well, I was going to aggregate with the other things that are taking place, Your Honor, that there's the arbitrary detention, and then there's President Bukele, who specifically said, we're going to detain all these individuals, then we're going to force like starvation on them, which I would argue is torture. Additionally, police and other security forces have been implicated in hundreds of extrajudicial killings. I would argue that killing satisfies the definition of torture. There's been numerous instances in the state of exception where the Salvadoran government has basically licensed impunity. I get it. El Salvador has had a major gang problem for the last 30 years. So President Bukele has taken what some of us may view as a rational step in trying to wipe out and incarcerate the entire population. However, in the process of doing that, he's done and committed massive human rights violations and ended up picking up, as the record supports, picking individuals who merely have tattoos, who merely live in...
Do you think that human rights violations are limited to torture?
I think forced starvation, I think forced
I
disappearance.
understand, but you can answer a different question later, but start with the question that I asked, which is, do you think that all human rights violations are torture?
No, Your Honor. But I do...
That's what I'm trying to get at, right, is that, we might agree or disagree with the approach that they're taking, but the question is why we think that this individual would be tortured.
Again, I would point to the arbitrary killings that are taking place by the death squads. The vigilante death squads that the IJ identified over 15 of from the record, they have been known to sweep neighborhoods and kill anybody suspected of being a gang member. All you have to do right now is report this there's a hotline in El Salvador that you can call and report somebody being a suspected gang member that's living in your neighborhood, and they come and pick them up, or death squads will kill them. Again, we may not have agreed with the IJ in the first instance, but given the rules of the game that we have to play here and the standards of review, there simply wasn't enough. I mean, I would invoke the First Circuit stinks like a fish standard here.
There wasn't enough to what?
To overturn the IJ's factual findings.
But don't we review that for just substantial evidence, right? Given the BIA makes that decision and it says that it finds it clearly erroneous, we just have to ask, is there substantial evidence to support that judgment? It doesn't have to be our judgment, right? It doesn't have to be that we would overrule the IJ as being clearly erroneous. We just have to be able to say there's substantial evidence that the BIA's determination, under its standard, which it says, is correct.
I disagree. I don't think the BIA can force its way into substantial evidence review when it has no factual finding ability. So how can, if we're going to give substantial evidence, which only applies to factual questions, how can the BIA have deference on factual findings that the IJ never made in the first instance? That to me, I know that we're at the level we're at, but that to me, we're flipping the standard, because if they applied an improper standard, that should get no deference.
But they said they applied the right standard, right?
But they also...
They say it over and over again.
But they also...
You just think they were lying, right? That they were not just mistaken. You would have us conclude that they're acting in bad faith. So when they say we review this for clearly erroneous, that in fact that was a bad faith statement, that they were not doing that and they were simply trying to trick us.
But then I guess I'm very confused then how you deal with their own statement where they say upon de novo review, we conclude.
Are you not arguing that the BIA's adopted a policy that they're going to reverse the IJ's when they grant relief?
I think that the BIA...
As a matter of policy, they aren't going to go along with the IJ's rulings that grant relief. You're not arguing that...
No, Your Honor.
That they're done something like that, are you?
No, I mean, I think that the BIA can overturn legal conclusions in the first instance that would have sort of an ultimate...
Not only can, they're obligated to, aren't they?
Yes, Your Honor, I'm in full agreement.
They're obligated to get it right.
Yes, Your Honor. But I'm just saying...
And the IJ is obligated to try to get it right. That's what everybody's trying to get it right.
Yes, Your Honor. I just think that this court has seen many IJ decisions in its history, and given the sort of thoroughness and completeness of this specific decision, I think that if the court were looking at that, it would have a very hard time utilizing the clearly erroneous standard to overturn what the IJ did. Again, she cited to the record more than 50 times, and given this actual underlying record, I just don't think that there's enough, even if the BIA were to try to go to cherry pick like they did with stale evidence, or using sort of non sequitur evidence that doesn't really rebut the IJ's findings, I still don't think there's a way to cherry pick through this record to overcome the IJ's decision, Your Honor. And so for that, we would ask the court to.
Did you represent this fellow in the IJ and BIA proceeding?
So I did not represent him at the initial immigration judge decision, Your Honor. I represented him starting at the first BIA decision and then on the immigration judge remand and then back before the BIA and now before this court.
Okay, so you've been in the case. So,
Not since the inception, yes, Your Honor, but for most of it.
well, he was pro se at the beginning.
He was pro se, and then because he was found incompetent, he got qualified representation, Your Honor.
Yeah. Thanks very much.
Thank
You
you.
saved some time.
Thank you, Your Honor.
Let's wait unless Judge Keenan has a question.
No, thank you.
Ms. Dew?
Good morning, Your Honors. May it please the court, Linda Doe for the respondent, United States Attorney General. Here, the board's reversal of the immigration judge's grant of cat deferral was reasonable because substantial evidence supports the board's determination that the immigration judge clearly erred in finding that petitioner would more likely than not be arbitrarily detained and tortured because of his non-gang tattoos and criminal history. The board set forth 3 reasons finding clear error in the immigration judge's decision. First, the board held that the immigration judge mischaracterized and failed to consider the significance of DHS's rebuttal evidence. Second, the immigration judge failed to distinguish between the likelihood of torture from that of lesser mistreatment. And third, the immigration judge relied on over-inclusive anecdotal evidence to find that petitioner has would be at particularized risk of torture. It's important to note that in this case, petitioner was not tortured in the past and does not allege that anyone in El Salvador has an interest in him for any reason. His claim is premised on a chain of events that he speculates that will take place upon his return. Regarding the board's first determination, the board reviewed the immigration judges and relied on the facts found by the immigration judge in noting that, including the testimony by petitioner's expert, Dr. Bishop. There, Dr. Bishop opined that tattoos were really the key and that they held such a gang significance that was nearly impossible to, it would be nearly impossible for the public or officials to believe that any tattoo, regardless of its depiction, was not gang related. And the immigration judge, Dr. Bishop opined that there was a narrow exception for foreign expat surfers. Here, the board explained that the immigration judge's finding was clearly erroneous because it failed to consider and mischaracterize DHS's rebuttal evidence, which the judge acknowledged included maps and listings of tattoo stores throughout the country, as well as conventions. The evidence signified that the tattoo culture in El Salvador may be much more greater than that opined by Dr. Bishop, and that simply having a tattoo was not definitive proof of gang affiliation. According to Dr. Bishop, any tattoo, Taylor Swift tattoos, rainbows, Care Bears, was sufficient to conclusively find that a person was a gang affiliate. Here, there was no indication that the country of El Salvador had banned tattoo shops or foreclosed the conventions due to its inherent and conclusive belief that tattoos were inherently gang affiliated. Because the immigration judge mischaracterized the evidence and failed to consider the significance of the evidence, including the fact that there's tattoo stores located throughout the country, including in landlocked
You're saying
areas.
everybody down in El Salvador's got tattoos?
No, Your Honors, but DHS submitted evidence that there was tattoo parlors not only in the coast of El Salvador, but throughout El Salvador, indicating that customers were not limited to solely expat surfers, and that they submitted pictures of tattoos of flowers and exotic animals, showing that tattoos were not solely limited to the surfer culture or gangs, such that, again, just simply having a tattoo wasn't decisive and conclusive evidence of gang membership, as Dr. Bishop opined. And so finding, the board held that the immigration judge clearly erred in this regard. Regarding the second determination, the board explained that the immigration judge erred in her predictive findings because she did not distinguish between the likelihood of torture and the likelihood of lesser mistreatment. BIA relied on the facts found by the immigration judge, where she noted that deportees with tattoos had been harmed. In the immigration judge's decision, she noted that such harm included monitoring and tracking, which is at page 108 of the Joint Appendix, discrimination and harassment, which is at page 107, targeting, kidnapping, and beatings at page 103, and arbitrary arrests, detentions, torture, and extrajudicial killings. The board explained that the failure to distinguish between the likelihood of torture and mistreatment was clear error because it was, the immigration had made a leap in logic and skipped steps to conclusively find that the petitioner would more likely than not be detained and ultimately tortured. The board expanded that harassment and lawful detention did not constitute torture. Accordingly, the BIA did not conduct de novo review as petitioner opines or argues, but rather exercised its independent judgment to evaluate the legal significance of the evidence and the ultimate conclusion to which those facts lead. Moving to the third point, Your Honor, the immigration judge held that the predictive finding was clearly erroneous because the immigration judge relied on general anecdotal evidence to find that petitioner had a particularized risk of torture. And so finding the board considered the immigration judge's findings of facts, including that he had relied on anecdotal evidence that death squads and the government had been known to commit extrajudicial killings and had been known to tamper with evidence. However, the incidents where death squads target persons, such as a petitioner, persons with criminal histories and non-gang-related tattoos, was not quantified. Additionally, the evidence was over-inclusive, including confirmed gang members, suspected gang members, former gang members, as well as civilians. And it lacked the specific relevant details pertaining to petitioner's claim based on non-gang-related tattoos. The board also considered that the judge considered that there had been 296 complaints of misconduct, including torture, and found that the evidence did not suffice to correct the error because it did not show that tattoos significantly increased petitioner's risk of harm, or that petitioner possessed a particularized or individualized risk of torture based on his non-gang tattoos. Having reviewed the entire record, the board was left with a firm and definite conviction that the immigration judge had made a mistake. In light of the foregoing, substantial evidence supports the board's determination that the immigration judge's factual finding was clearly erroneous. I request that the court deny the petition for review.
Your request is that we deny the petition for review, not that we affirm, just deny the petition for review is what your position is, right?
Or uphold the board's findings.
But what do you want us to do? What's the government want us to do, or the Attorney General? Affirm, uphold, or deny the petition for review?
Deny the petition for review, Your Honor. I request that they deny for review. If there are no further questions,
Thank you very much.
Thank you.
Mr. Osorio?
Yes, Your Honor. I just would point out a couple things quickly with regards to the tattoo. The findings are not that his tattoos won't be viewed as gang related. The findings are that he has tattoos that are not actually gang related. But the IJ, again, the only one who has factual finding authority here, through the testimony of the expert witness, found that they would be viewed as gang affiliated. And including, he had different numeric tattoos that, given the MS-13 and 18th Street, that was one of the reasons that she opined that they might be affiliated or viewed as affiliated. So even though he has non-gang tattoos, the Salvadoran authorities, and that was the factual findings by the IJ, are going to view them as gang affiliated. So it's not.
I thought your argument or Bishop's claim was that anybody with any tattoos, because nobody in El Salvador uses tattoos except gang members. And so if you're in El Salvador and you have tattoos and you're not on a surfboard, then you are going to be a suspected gang member, whether that's like, the little butterfly on the ankle or, the teardrop on the face. That her claim, it seemed to me, was not specific to your client, but instead was that there is no tattoo culture, surfers accepted, that's not gang-related in the entire country. I mean, that seemed to be what she said.
I took Dr. Bishop's point as being anybody who has tattoos is suspect, and then upon further examination of those tattoos, especially in light, like I said, in this case where the petitioner has numeric tattoos on his body, that then they can become to be viewed as gang affiliated. I take the government.
Where do you want me to read that? Because that doesn't seem to be what she actually says. I mean, that might have been a better argument. I'm not sure that it helps here, but where would I read that? Just when I go to the JA? Because when I read her testimony, it didn't come across that way, but I may have skipped over the part that you're talking about.
I don't have the page number in front of me, Your Honor. I can submit a 28J, but the
No,
IJ's factual
I'll read
findings that cite to Dr. Bishop's testimony explain that this petitioner's tattoos is going to be viewed as gang affiliated. And so, again,
But your testimony is Dr. Bishop considered the specific tattoos that your client had and said, everybody with tattoos are suspicious, but his would be particularly suspicious because the dragon or whatever it was.
the eight and some of the Egyptian, I believe, symbolic stuff she believed.
Her testimony was that was what was going to make it, not just tattoos in general, but his particular tattoos. She reviewed his tattoos and provided a basis for finding that his particular tattoos were the problem. It wasn't just tattoos in the country in general, but it was his specific tattoos?
I think her testimony, again, is that tattoos is not a commonplace thing throughout El Salvador. And that's what the department's evidence was intended to try to rebut, that there are these presence of tattoo parlors in El Salvador. There's a surfing community. But then, so given that it's not common and given that historically it has been utilized by the gangs, her opinion was that tattoos put everybody on high alert. And then upon further inspection, and it's in the record, when individuals are deported to El Salvador, they're stripped down, they're identified by their criminal history, their tattoos are marked. And so the IJ's findings followed that to find and conclude.
I understand the IJ, but is Dr. Bishop the one that's connecting this, or are you connecting it?
No, I believe the IJ connected it using Dr. Bishop's testimony and the country conditions evidence that was in the record.
To your client in particular, his tattoos?
Yes, Your Honor, to make a particularized determination for how this particular individual is going to be treated going forward. And so if, again, the court does not believe our first point that the board necessarily engaged in clear error by reversing the IJ, I would still argue that our strongest point here should be then if the BIA believes that clear error has been committed, it must remand so that the factual findings can be made by the IJ in the first instance with those errors pointed out, that the board lacks authority to make an initial predictive finding of a likelihood.
Do you think that's true for the Fourth Circuit as well, right? So because we say in a variety of contexts that even on agency review, where the agency is supposed to make fact-finding, that we can, at least in some cases, say that the evidence presented here leads to only one conclusion, right? And so it's unusual, it would be odd for us to say that the BIA can't say, as it seems to do here, that your client, absent the clearly erroneous factual findings of the IJ, failed to meet his burden, and therefore the petition's denied.
If
the
I may,
application's denied.
if I may, Your
I'm
Honor.
sure Judge King will let you answer.
Thank you, Your Honor. So just quickly, I would say that may be true on the acquiescence piece. I still think, and I would point to my 28J letter on Santos Zacharia, the recent Fifth Circuit decision here, that there are times that, yes, the BIA is barred, and it's barred by its own regulations from engaging in initial fact-finding. And I just think that when you compare the IJ's decision to the BIA's decision, it is obvious on its face that the BIA has done that. And because that's sort of an abuse of discretion. That's a violation of the legal standards of review that should be in place, and for that, it should be remanded. Thank you.
And thank you very much, sir. We appreciate it. We'll come down and greet counsel, Judge Richardson and I, and then we'll take a brief break. You may be seated. Let's see here now. In our third case is Mr. Colorado Navarro versus McHenry. Ms. Blessinger.
Yes, Your Honor.
Good to have you with us.
Thank you, Your Honor. My apologies, Your Honor.
Go ahead.
Thank you, Your Honor, and may it please the court. Good morning. We ask that you vacate the board's decision in this case for one of three reasons. First, the board erred in finding that my client waived the right to call Dr. Montgomery as an expert witness when he won the case before oral testimony was taken. Second, the board committed legal error when it failed to fully assess the record in determining that it is not more likely than not my client will be tortured upon return to El Salvador. And third, the board abused its discretion in overturning the immigration judge's credibility finding. Unless this court prefers otherwise, I'll address these issues in that order. With regard to Dr. Montgomery, Dr. Montgomery was recognized as an expert.
Dr. Montgomery was the proposed expert.
That is correct, Your Honor, yes. And Dr. Montgomery, the page 6 of the respondent's brief in this case does correctly state that the department objected to the weight of Dr. Montgomery's testimony rather than her expertise at the trial level. On page 200 and
Why do you say that? How did they object?
they
Dr. Montgomery, because Dr. Montgomery didn't testify.
That's
right?
correct.
So how would they have objected to any of that until she testifies? I mean, they objected that she wasn't on the list. I get that, but when she didn't testify, why do we think that?
They indicated that that her testimony should be given limited weight, but actually in the department's own brief before the Board of Immigration Appeals, they do call her an expert in there. And
They called her an expert?
They do, in the footnote, in the actual body of the brief, they do say purported expert, but in the footnote where they stated that they were contesting her expertise, they do call her an expert in the beginning of that footnote, so.
And you take that to be a concession. So like if somebody offers somebody as an expert, right, we naturally refer to them as an expert, but they're not an expert until the court qualifies them as such.
Sure.
You calling them or the government calling them something doesn't make them an expert for our purposes until a court rules that they're an expert.
I agree with that, Your Honor. I mean, the court did refer to her as an expert.
They never got to her.
I'm sorry?
They never got to her. She was...
That's correct. The immigration judge.
What, were you at the proceedings?
I was, Your Honor. I was the trial counsel in that case.
Okay.
And so the immigration court on.
And you waived the right to, they say, to call her.
Well, Your Honor, I think that's not necessarily correct. So that is what the board is saying, is that we waived the right to call her.
The IJ said she was going to agree with you.
That's correct, yes. So the immigration.
And then you said, well, I don't need her.
That's correct, Your Honor, because the immigration judge was going to agree with us. The adjudicator found that we had met our burden and that we did not need to present additional evidence for a grant of deferral of removal.
But we've all been trial lawyers and know that's like the tactical call that you have to make, right? And right or wrong probably is the right call, right? But sometimes even if you can win in the trial court, you recognize you need to put on other evidence to, prevail on appeal. Like that's the tactical judgment, and that, which I totally respect, probably was the right call at the time from a counsel perspective, but it's still a tactical judgment to not put that witness on. You could have said to the court, to the IJ, excuse me, thank you, Your Honor, I appreciate that we're going to prevail, but we really feel like we need to put this evidence in so that the BIA has the benefit of that evidence when it's reviewing your wise judgment to grant my client relief. Right? That was an option available to you.
Well, if I were to take on that option, as Your Honor
But the
refers to
court
it as.
actually, I thought she said she would give you a continuance and let you call the witness later. and another when reconvened.
So the
She had to
immigration,
terminate the hearing,
the
but
immigration,
was willing to reconvene it to hear your witness.
so the immigration judge did indicate off the record that we could continue the matter and call Dr. Montgomery as a witness, but that the immigration judge was satisfied we had met the burden and was ready to enter a grant of deferral of removal.
Say that was off the record?
It was off the record,
If
but
that's off the record, how can we consider it?
he summarized it back on the record,
Okay,
and
she
that's,
summarized it back on the record.
Yes,
So
yes,
it's in
Your
the
Honor.
record.
yes, I apologize,
It's
Your Honor.
in the
Yes,
record.
it is in the
There's another
record.
thing concerns me when you talk about the record here. You know, we're talking about whether she was an expert or not, but her declaration, you say, is in the record.
That is correct, yes, Your Honor.
And if the declaration is in the record's the record.
Yes, Your Honor.
So you're arguing that it had to be considered as non-expert testimony? Or what's the effect of the testimony of Dr. Montgomery that's in the record?
So, if I
I
may,
mean, it says what her qualifications are, and it says what her opinions are. Is that right?
that is yes, Your Honor.
So if her opinions were before the IJ and the BIA, what are they considered as lay testimony?
I think they could be also considered as lay testimony.
But it's in the record here.
It is in the
And
record.
it's before us.
But there-
It's in the
but-
record as a disclosure, right? That when an expert provides a disclosure, but then the expert has to actually testify, be subject to cross-examination for it to be evidence.
Well, I think that it's the weight of the evidence that's really considered when you're cross-examining
That's
a
what I think it
witness.
is. I think it's the weight of the evidence. I think if it's put in the record, it's the record.
Yes.
So your view is that if a petitioner puts a disclosure, an expert disclosure in and chooses not to call that witness, what is the support for the cases or, CFRs or whatever, that the IJ has to consider the pre-hearing report that's submitted when you choose not to call that witness?
So I think that, I don't know the information off the top of my head, the case, but I can submit a 28-J letter later if Your Honor would like. However, I do point the court to the
Your
board's-
position is there's a case that says when the petitioner chooses not to call an expert witness, the IJ must consider the purported expert's statement that was submitted pre-hearing. The IJ must consider it?
Well, Your Honor, not must, but in this case, the immigration judge did admit it into evidence and did accept it as evidence. Now, the board's decision itself does say that they were going to give Dr. Montgomery's report limited weight, not as much weight, but they did not exclude her report from the evidence at no point. And so I do think that's important. I do want to return to Judge Richardson's question about whether it was a tactical decision or to call my client or to call Dr. Montgomery as a witness. And in this case,
You're saying it was not a tactical decision?
I think to one point it may have been. However, if we were to adopt the
Well, it has
government's
to be looked at the time it was made.
right,
And that was a tactical decision because you knew you were going to win. So you abandoned the opportunity to call your witness. And you won at that point. Now, if they later want to claim that that was ineffective counsel and that decision, that would be for some case down the road, not for this one.
what I think is important to note here is that if we were to adopt the
We
reasoning,
get that stuff in habeas corpus cases where lawyers have to make decisions during the fight. And
so I
they
recognize
get
that.
second guessed down the road.
I'll concede that it was a tactical decision there, but I think
But
what's
the tactical decision, if it is a tactical decision, that's part of practicing law.
right. But what's important here to note is if we were to adopt the government's reasoning that my client waived the right to call Dr. Montgomery as a witness, we in essence would be taking the power from the immigration judge and giving it to the Department of Homeland Security and continue calling witnesses until the department, rather than the adjudicator, is satisfied that my client has met the burden in the case. And in this case,
I'm sorry, I don't understand that statement at all, right?
Sure.
So in any trial proceedings, right, lawyers got to make choices about
Sure.
what they're offering or not offering. But it's not giving power to the other side. It's your choice. And so the IJ says, listen, this happens in district court all the time. counsel, I'm inclined to rule for you, but if you got something you want to add, let me know, right? And lawyers, smart lawyers at least, know to sit down at that point because they want to win at that stage. Now, they recognize, at least good ones do, that that creates some concern on appeal. But that doesn't transfer the power to the other side.
Well, I think in that case, if the court were to find that Dr. Montgomery's testimony were needed to grant deferral removal in this case, the board,
court,
I'm saying
which
the board.
court?
The board,
The
I
board.
apologize. So if the board were to
Well,
find
we
it,
used to call that vouching the record. If they wanted to go forward, if the court's satisfied you got enough, but we want something else, Judge, I want to vouch the record, make it more complete.
well, I
Or
don't,
somebody else might take a look at this down the road.
Belt and suspenders.
but I think if that were the case, then the proper remedy would have been to remand this matter to the immigration court for
Well, and
consideration
you
of
got a
that.
dissent at the board level that says exactly that.
Yes, that's
There
correct.
was a dissenting judge, you call them judges?
Yes,
The members of the board, or the board members, whatever they were, you got one dissent.
yes,
Out of
that's
the
correct.
three,
Yes,
just like this.
and
They said it ought to go back and consider the expert testimony.
yes, and I do believe that we should adopt the reasoning in Osmani and follow that. A remand is required if the
So is
immigration
your
judge.
position here come down to the fact you say that the dissenting judge got it right, and we ought to adhere to that?
Well,
dissent
in
and
one
send
instance,
it
yes.
back?
But I'd like to move on to the protection under the Convention Against Torture as well, if I may.
So
In this,
you wouldn't be satisfied just with that?
I wouldn't, because I do believe my client has on the record, I believe he met his burden, and I believe the board, while they called it clear error standard, they didn't implement that. And if we actually look to the citations that the board made, almost every citation the board made supports my client's case. In this matter, I went through the 2,000-page record, and I picked out the best 3 pages of evidence. And I point the court's reference to JA 1241, JA 1252, and JA 1478. Both 1241 and 1252 were cited by the board in its decision, and both of them demonstrate that it is more likely than not that individuals similarly situated to my client are to be tortured in detention centers in El
That's the
Salvador.
right standard, isn't it?
I'm sorry?
Is that the right standard?
That it is more likely than
More
not.
likely than not?
Yes, that is the correct standard in the immigration court level. With the clear.
That comes from the statute? That's in the statute?
Yes, Your Honor.
More likely than not?
Yes, Your Honor.
What's the difference between that and preponderance of the evidence?
I mean, I think more likely than not is 51%. More likely than not is a 51% chance that someone would be tortured if they were to return to their home country.
Is the preponderance not 51%?
I believe it is, Your Honor, but I'm not positive. I don't.
Are you saying they're the same thing?
I can't opine to that. I can just speak to what is more likely than not standard.
Yeah.
But I think what's important
Like
here.
I used to practice law. I never was in immigration proceedings, but we had a lot of civil proceedings,
Sure.
and the standards were preponderance of the evidence. And lawyers used to argue about 51%, 51%.
Then, yes, Your Honor. And so I draw the court's attention on JA 1478 to the Salvadoran government's own words, where the director of social fabric for the Salvadoran government, quote, called the treatment of those arrested during the state of exception torture, end quote. I mean, that is what is in essence happening here, and that is what the immigration judge found based on the record before him, and that should have been what the
Can you explain to me how this argument connects back to his credibility?
Yes.
If we, just hypothetically, for purposes of this question, accept that the BIA got it correct and your client was wholly uncredible, I understand that you have an argument that that's wrong, but just
Sure.
for a minute accept that premise. What effect does that have on this argument? Because he now lacks evidence. So in theory, he's as likely to be a gang member as not to be a gang member. He has multiple murders, right? So the facts, if you take his testimony out, look quite different. Is there any suggestion that if he's incredible, that he's done anything to establish what he has to under CAT?
Yes, Your Honor. So even if
So
you're,
how do we know that, if he's incredible, how do we know that he fits in the proposed social class that he's identified?
sure, the way that we know that is from the undisputed fact that my client has warrants for his arrest in El Salvador, the undisputed fact that my client will go to a prison in El Salvador upon return to El Salvador, and the undisputed facts within the record that demonstrate that individuals in detention centers in El Salvador are routinely being tortured by Salvadoran
So
officials.
your theory here is that it matters not whether he continues to be an active member of a gang or not? That makes no difference?
I don't believe it makes a difference, Your Honor,
And
because
so when he identified the social group, is the social group that he suggested to us, is it one that includes gang members and non-gang members?
well, in this case, it's protection under the Convention Against Torture, so there is no social group. But when the immigration judge was doing his analysis, he looked at whether or not suspected gang members, such as Mr. Colorado, would be tortured by members of the Salvadoran government. And that was the clear erroneous standard that the board erred on in overturning that, because the evidence shows that suspected gang members in prisons in El Salvador are routinely being tortured by the Salvadoran officials. The second group that the immigration judge found my client would be at risk of is from the 18th Street gang members, which if he were a member of MS-13 or if he were not a member of MS-13 wouldn't matter, because he would have been a member of a rival gang. And as a member of a rival gang, it is more likely than not he would be tortured by those rival gang members, the 18th Street gang.
And this is because he killed 3 of their members?
Not just that, but it's also because he was a member of a rival gang. And the evidence supports proof of that. The citations given by the board in their decision actually talks about the fact that previously MS-13 and 18th Street gang members were separated, but now they're being put together. The board says that they're being put together because they want to break up the lines of communication, whereas the evidence that the board cites to actually shows that they were previously separated because of the risk of harm between the two gangs inside the detention centers that the Salvadoran government allows to occur.
Ms. Schlesinger, I've got a question. If this man were given deferral of removal, what would happen to him?
If he were given deferral,
He's a self-confessed triple murderer, okay? So what would happen to him then, if we were to agree with you? What would be the next step if he's granted deferral of removal?
if he were granted deferral of removal, then he would have an order saying that he is not allowed to be deported to El Salvador, but then the Department of Homeland Security could opt to remove him to a safe third country in their eyes. And if it were a country...
They would have to take a confessed triple murderer, who is, at least on the record we have, likely a gang member. Right? So they would have to get a country to agree to that, right?
That is correct.
We would like, Belgium says, we would love to have a confessed triple murderer gang member. Will you send them to us?
I mean, that is what would happen, but that's not really the emphasis in this case, because the emphasis here should be whether or not
I just was trying to understand, to your question, and if that doesn't happen, to Judge Keenan's question, if that doesn't happen, so if other countries say, we prefer not to have a confessed triple murderer be sent to us, then what happens? He's just put back on the street?
He could be detained for up to 6 months, and if they can't find another country willing to accept him, then he could be released.
Could be, he would have to be released.
He would have to be released, and he would
Could
likely
be
get a
released
work
into the
permit.
population of the United States?
Yes, with his child who is autistic, which
Well, right now, he's detained, right?
he is detained, yes. But I would also note for the record that he did not have any convictions in the United States, and that is in the record while here in the United States, because he left the
That we
gang.
know of, but if BIA is correct, he's not been honest throughout. So we actually don't know whether he has convictions under different names or different stories or whatever. We actually don't know the answer to that. All we know is he confessed to killing 3 people in El Salvador.
I mean, we know that he confessed to killing 3 people in El Salvador, and that the immigration judge found that he credibly testified before him that he was no longer a gang member.
And your best argument is, on that point, is that the IJ saw him as a witness, the demeanor on the witness stand, and said, I believe him. And the BIA didn't.
I think that it's really, and I apologize, I'm over the time. I think that it's important to note that the immigration judge not only saw him, but this is an immigration judge who has been a judge for 7 years, previously served for 15 years at the Office of Principal Legal Advisor, 11 years as the chief counsel in that office. And he observed my client's demeanor, compared the applications, and this is a judge who routinely oversees detained cases.
Do you think clear error takes into account the immigration judge? I mean, it'd be a little odd for us to say as a court of appeals that, oh, we review this district court judge for clear error, but this is a really good district judge. Like, we really like this district court judge, and so clear error means more for this district judge than it does for a district judge that maybe, I don't know as well. I mean, that would be an odd way to run a railroad.
I mean, I agree with that, but I think that the reason I'm giving you the background information on him is because just as Ming Dai contemplates, the immigration judge is best suited to make the initial credibility finding. So knowing his background shows you how suited he is to make that initial credibility finding. This is a judge who routinely deals with persons in detention and understood why he didn't understand the initial application that was presented to the immigration judge because of the issues with representing detained individuals.
Let's go back to Judge Keenan and see if she has anything else.
No, thank you.
Ms. Richardson and I got into it after she brought it up. Judge Keenan?
Judge Keaton, did you have any other questions?
No, thank you. Yeah, I'm all done. Thank you.
All right, you
I'm
save
sorry.
some time.
Okay, thank you, Your Honor.
Thank you. Ms. Groff?
Thank you, Your Honors. May it please the Court. Stephanie Groff for the Attorney General. Your Honors, this case truly comes down to our immigration system's own checks and balances, specifically as the Board is the highest administrative body for interpreting and applying immigration law and reviewing immigration judges' decision. As Judge King noted in the previous case, it's really about trying to get to the right answer, and that here is what the Board was doing. It reviewed the immigration judge's decision properly, noting that it reviewed for clear error the factual findings, and ultimately determined that the immigration judge here made severe and unsubstantiated statements in its finding. I want to also point this court to two decisions from the Board of Immigration Appeals that Mr. Colorado cited in his reply brief. They're matter of JGT and MAMZ. They specifically address how immigration courts handle the proposed expert testimony. In neither of those decisions does it state that an affidavit that's submitted by a proposed expert must automatically be taken by the adjudicator, the immigration judge, and be found to be an expert. In fact, matter of JGT specifically goes into how a non-citizen or the Department of Homeland Security, as both can present witnesses, should propose an expert witness. It states that a resume, may be filed, an affidavit should be filed, and if necessary, the opposing party, if the opposite party does oppose, has the opportunity to voir dire. With that in mind, here, Ms. Blessinger noted today before this court then concedes that she made a tactical decision to not call Dr. Montgomery as her expert. The record.
What do we do with this? It's a little ambiguous, but what do we do with the written declaration of Montgomery? Because the IJ doesn't, explicitly incorporate it or adopt it. There's a strategic choice not to call them. And then we get to the BIA, and the BIA says, not exactly clear what this is, but if it's anything, we give it very little to no weight. Can a witness statement, when the choice is made not to testify, could the IJ decide to consider that as that, sort of informal proceedings that would permit that?
Absolutely, and that is well supported in almost every circuit. But what specifically is missing here is Ms. Blessinger decided not to call Dr. Montgomery, and it would have been more prudent, again, not to question her choices, but to potentially pose a proffer to state this is, Dr. Montgomery would have testified exactly with what the affidavit said, leave it up to DHS then to say, we agree with that, we're okay with that. But that's not what happened here. She declined to present the testimony. She made no statement with it.
She didn't make a proffer?
She did not make a proffer.
She didn't vouch the record?
No, Your Honor.
But she put the declaration, and she calls it a declaration, and the record I think that's what it's called. You said, you talked about affidavits.
Affidavit and declaration,
Well, you say they're equivalent?
they're interchangeable when it comes to these
They are,
proposed
well,
expert witnesses.
Declaration are defined in this code, I think.
Well, when it comes to immigration court proceedings, if a expert is going to testify, and a lot of times experts aren't presented to testify, they submit a declaration affidavit. And here, the immigration judge had the opportunity and did consider it. Specifically, Ms. Blasinger noted in her opening brief that the immigration judge said that it took into consideration the expert declaration. What's important here, though, the board noted in making its clear error review when it comes to the CAT, the Convention Against Torture Protection, that the immigration judge, in rendering its finding, made no reference to Dr. Montgomery's testimony, or Dr. Montgomery's affidavit, sorry. And in doing that, the board found that on appeal, when Mr. Colorado filed his brief before the board, over-relied and stated that Dr. Montgomery says that there is a 100% chance that he will be killed and tortured if removed. The board found that, yes, while this is in the record and the immigration judge had the ability to look at it, the immigration judge here did not rely on it. Instead, the immigration judge made unsupported and unsubstantiated statements, and therefore the board determined that in rendering its clear error review, it was not going to.
Well, so you're saying that the BIA considered it to be irrelevant?
Not necessarily it's that it was irrelevant.
Surplusage? What is it?
The board found that in looking at the totality of the evidence, that it was not going to give, it was not taking exactly what Dr. Montgomery said and giving it more weight to then the other record evidence. Here in its clear error review, which I will note this court reviews whether the board made the right decision under the substantial evidence standard, as Judge Richardson has mentioned before, the board here looked to the record evidence, looked to the immigration judge's decision, specifically when it comes to CAT, and found that his baseless statements were unsupported. The immigration judge is the adjudicator in these matters. The immigration judge has the duty to develop the record, but ultimately it's the respondent's burden of proof, the non-citizen's burden for CAT protection. And here, the board decided that in looking at the immigration judge's decision and factual findings, they were speculative. They were not based in the evidence. The board specifically looked at the evidence, did not make its own factual findings, and found that a clear error it was clearly erroneous to make this finding. And bringing it back to Dr. Montgomery, the board found that because Ms. Blesinger made the tactical decision, she waived her opportunity, that it was not going to over-rely on that statement. I will also note that remand is not appropriate. Yes, Your Honor.
If I could ask you a question. One thing that interests me, maybe concerns me about the BIA's opinion, it seems to be kind of a numbers game. In other words, it's throwing out how many people were detained versus how many people were in prison versus how many people who died in detention. And is that a valid analysis for a BIA in reviewing a record? They seem to be resting on a numbers analysis. And could you respond on that?
Yes, Your Honor. The government agrees that there is a lot of numbers, and while that's not my forte, the government argues that the board's decision here is proper, and it goes back to their applying the substantial evidence, the clear error standard of review. For clear error, it is whether if there are two permissible views of the evidence, then it could not be clear error. The board's decision, and in noting numbers, looked to what the immigration judge found and held that the immigration judge's statements were unsupported, they were speculative, and therefore it was not a permissible view of the evidence. And in rendering that conclusion, the board then looks at the totality of the evidence, which as an administrative review court has the ability to do, to look at the totality, and pointed that the immigration judge's findings were unsupported. When it came to numbers specifically, as it relates to the likelihood of harm, the immigration judge stated that hundreds of people have been reportedly killed and tortured. The board took that and stated that this is unsupported. And looking at the board and the immigration judge's decision, his cite to the record did not specifically support what he stated. And then the board looked to the record evidence, noted that yes, the state of exception is happening. There have been about 84 people that have been killed in these operations to arrest people. There is also evidence that a certain amount of people have died in detention, but the board found, based on the record evidence, those that have died in detention show even fewer show signs of torture. And that's what's really important here. Specifically, Mr. Colorado has the burden to prove that it is more likely than not that he will be tortured if removed. And being arrested is not just torture, and being in poor country conditions, while the government obviously does not condone torture, does not meet his burden. And so the board here did not render its own factual findings. It is in the regulations that the board can look at the most recent country conditions report to take administrative notice, and in doing that held that the immigration judge here clearly erred. Now, where this court comes into play is whether that is supported by substantial evidence. And Mr. Colorado has failed to point to evidence in the record that compels a contrary conclusion. Even the evidence that Ms. Blessinger noted before this court does not compel a contrary conclusion. In addition to whether there's a likelihood of harm, Mr. Colorado also needs to point to the fact that it is with the specific intent to cause this harm. And while there is evidence that government officials in El Salvador have noted that they want to control gangs and that there may be issues as it relates to this, that does not meet the high burden that there is a specific intent to torture, to harm them, and it's the government that is doing that. The record evidence also shows that for years, 30, 40 years, El Salvador has been ridden with gang violence. The state of exception is a constitutional authority that was invoked by President Bukele to control the country.
Okay, now, Ms. Grafo, one thing I'd like to ask you about, though. You said they have to show a specific intent to torture? I
Yes,
don't
Your
see
Honor.
that anywhere. Don't they have to show, doesn't a petitioner have to show that it's more likely than not that torture would occur? I mean, torture could occur because of lack of training, because of ignorance, all sorts of things without a specific intent to torture. Seems to me that you're adding something on there.
Sure, Your Honor, and let me just clarify. The specific intent language comes from the definition of torture itself. Specifically, it constitutes torture if it's specifically intended to inflict severe pain or mental suffering, and that is in the regulations at 8 CFR 1208.18A5. This court also in Oxygena v. Lynch noted a specific intent to torture. Additionally, there's the board's decision, a matter of JRG.
But is there anything that says there has to be proof of a specific intent? Generally, specific intent is something that exists before the act, is it not? In other words, I have to intend to do something, and then I carry out that intent. And it seems to me that you're elevating the requirement here by requiring as a precondition of torture that somebody actually intend to do it, that they have to prove a prior intent before the act occurs.
And Your Honor, I do not mean to create a new standard or show that that has to be proven. However, with Convention Against Torture Protection, the ultimate question is whether it's more likely than not that he would be tortured. As noted previously, that's that more than 51%. In that more likely than not, that includes the definition of torture. So the board here properly noted that Mr. Colorado did not demonstrate more likely than not that he would be tortured, and in that did not demonstrate the specific intent element that the Salvadoran government here is intending for this harm. And the board, in making that finding, noted that the immigration judge made a comment that, it could show possibility that the government is wanting to torture. But the board looked at the record evidence, which it has the ability to do, and noted that there is evidence that the government is seeking more funding for more prisons, is stopping the overcrowding and making efforts to make it more reasonable, and cited to the board's decision in JRGP, which showed that these efforts and underfunding and efforts to make conditions better does not show that specific intent element. And notably, the record here does not compel a contrary conclusion to that of the board. And I do want to go to the credibility finding here. As Ms. Blessinger noted, a non-citizen can receive cat protection even if they are not credible, but here substantial evidence more than supports the board's finding that the immigration judge's decision was clearly erroneous. Specifically,
Now, she found him credible, or if it was a she, found him credible, and said that he apparently misrepresented or lied on 2 previous applications,
yes, Your Honor.
correct?
Yes, Your Honor.
And then the Board of Appeals said that was an erroneous ruling, so he confessed to 3 murders, and the judge found him credible. And when he had denied the murders, so he was apparently, they said he was lying. So you all, the BIA said he was not credible when he confessed, right? So you don't admit that he's a murderer. So
No,
you've acquitted him.
No, Your Honor. Let me just clarify. When the board...
Well, the judge said he's credible, and part of it was that he confessed to crimes on the witness stand.
Well, the board's decision
That went
is...
to his credibility, and the judge analyzed it and saw him and said, I believe him. And the BIA then says, well, we overruled that.
And in doing so...
So that means he didn't commit the crimes. At least he wasn't credibly, the testimony wasn't credible enough to mean that he committed the crimes.
Well, Your Honor, that's a catch-22 and not what the board was holding here. Specifically, the
Well,
board was...
that's just what they held.
They held that they found that the
They held that
immigration
the credibility ruling was wrong.
was clearly erroneous, but it
Clearly
did...
erroneous, that's wrong. Clearly erroneous is wrong. The credibility ruling was wrong. It was clearly erroneous. So, you didn't believe, for the purposes of the BIA ruling, he didn't commit any crimes. Didn't commit any murders. He might have committed some crimes, I don't know. It might be, I haven't looked at the detail of it,
Your Honor...
but he didn't commit the murders for sure, based on the BIA ruling.
The government respectfully disagrees. In fact, the board's decision
Well,
shows
then
that
you're
it's...
picking and choosing. You were saying
No, the board
the credibility
isn't
ruling
sure...
still permits you to cherry pick.
The board did not cherry pick here, and the government is not cherry picking. When the board found that the judge's decision was clearly erroneous, it was not stating that everything that he agreed to and stated was true is now false. In fact, the board, in this record,
It doesn't have to go that far, right? Because they're like arrest warrants. Like
There are arrest
For the BIA's purpose, it doesn't have to rely on his admission. There's other evidence in the record that he killed these 3 people.
Absolutely. There's not
So
only...
whether you just wipe his testimony out altogether, that would not mean he didn't commit the murders. It would mean maybe he didn't confess credibly to the committing the murders, but there's sufficient evidence, substantial evidence indeed, in the record that he committed the murders independent of his own admissions.
Absolutely, Your Honor. And the board...
So we could disregard the credibility ruling and still rule in your favor.
Absolutely. And in
Well,
fact...
that's sort of what I'm getting at. Why, you're arguing about all this credibility stuff.
Well, I was just
but
referencing...
But you don't need it.
Yes, and I can happily move on, but as to Judge Richardson's point, it is, whether or not he was credible or not, there are multiple Salvadoran arrest warrants for his murder. Also, Mr. Colorado submitted his own arrest warrants in the United States, which noted that he is on an FBI watch list for MS-13.
Yeah, but, and your opponent there says that if he gets deferral of removal, he'd have to be released on the street in the United States?
So I'm
agree with
happy to clarify that. So deferral of removal specifically is intended for, may I say, the worst non-citizens, specifically those who have been convicted and sentenced and are in Guantanamo Bay, as it is to terrorism attacks. The Convention Against Torture deferral still protects them. But in order, if a deferral of removal is granted, say if it were to be sent back to the judge, what happens is that the Department of Homeland Security has the ability to work with other countries, to work with some of our
But
territories.
nobody will take him. Nobody would take him.
Well, Your Honor,
That would be-
that is Beyond the scope of what we have here, there is numerous instances where certain countries, for instance, Palau has taken terrorists that have come from Guantanamo Bay. We don't know that here, and that's beyond the scope of what we have here. What we have here is a well-reasoned board decision that found clear error in the immigration judge speculative and jumping to conclusions decisions, and the record does not compel a contrary conclusion, even ignoring the credibility finding that Mr. Colorado has met his high burden of proof that it's more likely than not that he would be tortured.
Just to make sure I understand your point about the deferral, I understand that you're positing that the government could convince some other country to take this petitioner, but do you agree, if not, that he would then have to be released?
If not, yes, he would have to be released. There is no detention that can be longer than, as my friend on the other side said, for 6 months. He would be released into society. I believe he currently lives in Northern Virginia. Ones who get Convention Against Torture deferral are not eligible for certain benefits, I will note, but it is still a protection that they are not allowed to be removed to their home country. But here, what we have is a non-citizen who, either admitted or not, is going to be arrested. No one contests that if removed to El Salvador, and he is not proven that it's more likely than not that he would be tortured if removed. It's his burden. He did not prove that. He did not proffer the witness, and the board properly noted that even if Dr. Montgomery were to testify, it is not necessary here, and remand wasn't necessary. And I will just make one more point on Dr. Montgomery's statement, and I said this in my answering brief. Even assuming that it was an error for the board not to remand, as the dissent noted, and the board, Mr. Colorado has not proven that anything in Dr. Montgomery's affidavit or declaration would change the result of the case. Dr. Montgomery made a statement that it's 100% chance that he will be tortured, but it does not address the state of exception as it relates specifically to Mr. Colorado. It also does not address country conditions as it relates to overcrowding and how it will directly affect Mr. Colorado. And therefore, we'd ask this court to uphold the board's reversal of the immigration judge's decision and deny the petition for review.
Thank you very much, Ms. Groff.
Thank you.
Ms. Blessinger?
May I proceed?
Go
Thank you,
right
Your Honor. Your Honor, I think it's important to note here that my colleague stated that Dr. Montgomery's testimony was not needed, absent it would not cause any prejudice to my client. However, the Board of Immigration Appeals specifically referenced a 2022 Human Rights Report in its decision that Dr. Montgomery did not have an opportunity to opine on, and actually does also support my client's likelihood of being tortured in El Salvador. But Dr. Montgomery's testimony would be relevant specifically to that report, Your Honor. Your Honors.
I'm sorry, say that one more time. So your argument that Dr. Montgomery or her?
It's a she, yes.
Okay, thank you, sorry. That her testimony would help because Dr. Montgomery would have testified to things that were not in her written declaration.
I mean, she would testify.
That's the premise of that point is that
Right.
Dr. Montgomery would not have limited herself to her written declaration, but instead would opine on other things that would have been pertinent. And in
Correct.
your view, that's permitted in the immigration system that you can give an expert disclosure, but the expert is not, as they would be in federal court, they're not bound to testify only to things included in the disclosure. They can testify about anything they want to.
That's correct. The affidavit is more of a, similar to, it's akin to a proffer, almost, a written proffer. So I do think that's relevant. The other is, Your Honors had asked what would happen if my client were to be released. I also do want to note that in addition, he would have to report annually to immigration, and each time at that annual reporting would likely need to provide proof of his attempts to find a safe third country to take him. With regard to the funding for prisons, I encourage this court to look at each citation that the board made in its decision. Each and every citation shows that the funding for the new prisons is only to allow the Salvadoran government additional room to torture these individuals rather than actually help their conditions. With regard to my colleague's statement that the immigration judge has the duty to develop the record, we wholeheartedly agree with that, and that's why this case should not have just been reversed once the board found that my client did not call Dr. Montgomery as a witness. My client never waived the right to call Dr. Montgomery as a witness. It's just that the judge, in following his duty to develop the record, found that we didn't need to present her evidence and didn't need her oral testimony to grant deferral.
You don't like that word waiver.
I mean, we never waived the right to call her, so yes, I don't like that word because it mischaracterizes what happened. As my colleague noted,
Is there ever a strategic decision in your view that would constitute waiver? Or the strategic decisions just don't matter? So your choice to call or not call witnesses, or include or not include them on the witness list, if you get to the BIA and the BIA disagrees, you can say, well, we have these 5 people. They weren't on the witness list. We didn't call them, but we didn't waive the right to call them, so we should get to call them now. Is there ever a point in which strategic decisions matter? Or is your view, like, you can make strategic decisions, but just sandbag it up? So you get to the BIA and you say, well, you know, yep, I chose not to call these 7 people, but now that I lost, I want to go back and have another crack at it.
That's a completely different scenario because in this case, we listed.
Do you agree that waiver would apply there?
I think so, yes, Your
Okay.
Honor. I would agree in that circumstance if they're not on the
So it's not
witness
that you
list.
can't waive things, you just think your strategic choice here doesn't, like, amount to it?
Correct, because we.
Can you help me understand where the line, how you draw that line?
Sure. On the administrative record, page 241 and 242, you'll note that we stated we wanted to call Dr. Montgomery as a witness. Then the judge went off the record and said, you've won the case without using Dr. Montgomery's testimony. And then we went back on the record, he summarized that, and asked if we wanted to rest on that evidence. I mean, that's completely.
And you made a choice to say yes, right?
Because the immigration judge said they were satisfied. I mean, that's the immigration judge's, he was satisfied we met the burden.
So so your line is that anytime the court tells you you're likely to win, your strategic decision is no longer a waiver. So it turns on whether the immigration judge forecasts the ruling before you make your decision. And then it's not a waiver because it's, involuntary? Why is it not a waiver? Is the line that it's no longer voluntary?
I think it's not a waiver because the immigration judge finds that you've met the burden. I mean, the immigration judge in this case said, if we were to rest on this record, you've met your burden. And I think that's the distinction here. And so
But you're running the risk you're going to get reversed.
Well-
Anytime a judge rules, the other side can appeal it.
right, but then the other.
There's a risk for you to say, we're not going to call them.
But I think what's relevant is what the adjudicator wants in that case, and the adjudicator found that we had met the burden on the record before it. And I just want to point one thing, if I may. I know I'm over time, but just if I may point the court to Administrative Record 1379. It does show that the unlawful killings of suspected gang members and others are being made by the Salvadoran security forces. And so I think that's also relevant to showing that Judge Choi's decision was well-reasoned and that the board, while they called it clear error, did not follow that standard. And the dissent notes that as well. Thank you.
Thank you very much, Ms. Blessinger. We appreciate your work.
Thank you very much.
And Judge Richardson, I'll come down and greet counsel.
Thank
Did I
you.
need to check to see if Judge Keenan had anything?
Pardon?
Just because Judge Keenan is on the screen, I didn't know if I needed to check.
Oh, I'm sorry. Judge Keenan?
No, I want to say thank you.
Thank you, Your Honor. Thank you.
Judge Richardson and I'll come down and greet counsel. We'll adjourn court for the day, and then the court will reconvene for the conference.
Okay.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.